Okay. All right. Good evening, everyone, and welcome. My name is Adam Carson. I am an associate planner with the Rockland County Planning Department, and I'm also the executive director of the Rockland Municipal Planning Federation. Welcome to session 2 of our certification series, the update of case law. By way of background, the certification program started in 1993 when towns and villages within Rockland County, in cooperation with the Federation and the county, enacted specific training requirements for Planning Board and Zoning Board of Appeals members. As a result of these agreements, board members in Rockland County must complete 3 training sessions to be certified and retake session 2, tonight's session, every other year to be recertified. Session 1, overview of the boards, was already held back in March. Session 3 used to be held on a single night, but broke down into two separate meetings, one for planning board members and one for ZBA members. With our training sessions currently being offered virtually, we are holding 2 separate sessions. The ZBA working group will be held on Tuesday, May 31st, and the planning board working group will be held on Thursday, June 16th. Before we begin, I have several housekeeping announcements. Session 2 is unique among the various programs that the Federation offers in that attorneys can receive continuing legal education credits for attending. In order to meet the requirements of the New York State CLE Board, tonight's session will be slightly different from our other sessions. Throughout the night, I will announce attendance verification code words. This is required by the CLE Board to confirm attendance at webinars. I'd recommend that any attorney seeking CLE credit write them down. If you are not an attorney seeking CLE credit, you can ignore them. In addition, every attendee will receive by email a course evaluation form and an attorney affirmation form. Again, if you are not an attorney seeking CLE credit, you do not have to return them. If you are an attorney and want CLE credit, you will have to complete and return the affirmation form. Since we are on the subject, I will give the first attendance verification code word now. It is Rockland. Next, Rockland Municipal Planning Federation is a nonprofit organization with officers elected by its membership. These elections are usually held at our annual dinner, which has not been held for a few years due to COVID. At the end of tonight's session, there will be a virtual election for positions on the board of directors. Any member of the Federation may cast a ballot. If you are an appointed or elected official in Rockland County, municipal or county staff, or a dues-paying associate member, you can vote. You can see that my email address is on the screen now. If you are on a board outside of Rockland County and need a certificate of attendance, please email a request to me that includes your name, municipality, and board. The Federation maintains attendance records that we share with towns and villages within Rockland County, so local board members do not need a certificate. Next, everyone is muted and will stay that way. If you have a question, please use the question function. I will be monitoring the Q&A, and I'll relay your questions to Christie during the session. We may pause for a little while because I don't want to interrupt her. There is a lot of material to cover, and I don't want to get in the way of Christie's flow. So we are very lucky to have Christie Tomm Addona with us tonight, or back with us tonight. She's done this several times for us. She is a partner at Silverberg Zalantis LLC, where she works on litigation and appeals as well as land use applications. She advises municipal boards, including those in the towns of Haverstraw and Ossining and the village of Tarrytown. She also counsels parties appearing before municipal land use boards. In addition, Christie has worked on a number of Article 78 proceedings, either defending or challenging administrative decisions. She further assists the firm's clients in drafting commercial contracts, including leases, contracts of sale, and construction contracts, advising on employment law issues and commercial litigation. Christie regularly lectures on zoning and land use topics and has been acknowledged in the 2018, 2019, 2020, and 2021 publications of New York Metro Super Lawyers as a rising star in the area of land use and zoning law. Prior to joining Silverberg Zalantis LLC, Christie was employed by civil litigation law firms and worked on cases from commencement of lawsuit through trial and appeal. Christie has worked for a variety of clients, including large corporate entities, not-for-profit corporations, and individuals. Her prior experience includes insurance, defense, tort, and maritime law. Christie received her Bachelor of Arts with majors in economics and history from Swarthmore College and graduated magna cum laude from St. John's University of Law. She's admitted to practice in New York, New Jersey, the Federal District Court of New Jersey, and the Federal Southern District of New York. So I think we are very lucky to have Christie with us tonight. I will stop sharing my screen in a moment. There we go. And Christie, feel free to take it away.
Good evening, everyone. I hope you're doing well. One day I hope to be back in person, but I think we have a good system going here. Thank you to Adam and Helen for making this happen. You could see on your screen that I did prepare a handout in advance that I sent to Adam and I believe was circulated to everyone. But for those of you who may not have gotten it or who may not be able to have it up on your computer while you're watching this, I'll try to scroll down periodically as we're going through so you can follow along, although my comments will be a lot more detailed than what's in the handout. So I'm going to try to discuss all the cases tonight, but if I don't, at least you'll have a synopsis of what I consider to be the most important aspects of the case. For those of you who were on about 5 minutes ago, you heard me and Adam talking about taking questions. We're going to do that periodically as I finish certain topics throughout the night because there is a lot of material to get through and I don't want to keep you here too late. It's the start of a holiday weekend, so I appreciate all of you being here with us tonight anyway. And so, but I'm welcome to stay on I'm happy to stay on after 9 o'clock to discuss further and additional questions. I just want to remind everyone this is a case law update. So I'm happy to answer questions about the cases or general legal principles, but it's not really, I can't get into, specific hypotheticals or scenarios that I'm not familiar with. So I guess with that, we're going to start with site plan and special use permits. I'm going to run through these pretty quickly. A few of these cases are carryovers from last time. We usually leave them on the handout for 2 sessions. So a lot of these will be coming off and hopefully there'll be some new good ones coming down. But I do think that these are important legal principles and concepts that the board members probably deal with on a regular basis. So I'm just going to start and run through these site plan and special use permit cases pretty quickly. The first case is Muller versus Zoning Board of Appeals of the Town of Lewisboro. And in this case, the petitioner had 11 dogs that he housed on his 2-acre property, which was in a residential zoning district. A dog kennel was a special permit use, but had certain conditions associated with it, specifically that the property had to be 4 acres and you couldn't have more than 10 dogs. So his use of 11 dogs on 2 acres did not comply with that. So in addition to seeking a special permit from the zoning board, he also sought variances from those conditions of the special permit use. The zoning board decided to deny both applications, and petitioner brought an Article 78 proceeding challenging the denial and also brought a declaratory judgment, action claiming that limiting the number of dogs he could have on his property violated his constitutional rights. So the court explained that the standard for a special use permit is one where the local legislative body, which in this case is the town board, has already found this to be an appropriate use for the zoning district. As a result, if the applicant can comply with the conditions in the code for that use, it will generally be approved. The court also noted that because these are conditions set forth by the legislative board, the board that's granting the special permit, in this case, the zoning board, does not have authority to quote unquote waive those conditions. They can't just say they don't matter or we don't have to consider them. What the zoning board can do and what the applicant asked them to do in this situation was grant an area variance from those conditions. So that's an important distinction that I think could come up when a lot of the boards are considering special permit uses, is that there is relief available, but it has to be in the form of a variance. So ultimately, the board, as I said, did decide to deny both of these applications. And once they denied the area variance, which we'll discuss more later, the court found that it was appropriate for the board to also deny the special use permit, because even though it is presumed to be a permitted use, that's only when the conditions of the use are met. And in this case, without getting the variance, those conditions were not met, and so it was appropriate to deny the special permit use. With respect to the constitutionality claim, the court also dismissed that in dismissing the Article 78 proceeding, and the court found that to be improper. Because when you challenge a municipal action or an agency action, board action, you do it in what's called an Article 78 proceeding, which is most of what we talk about. And it's a summary proceeding. So it's basically a motion, and it doesn't go through all the normal channels that you would go through for a regular litigation, like discovery and motion practice, depositions. And so an Article 78 proceeding was not the proper venue for the court to say that the constitutionality claim did not have merit. So while the court did not specifically address the merits of the constitutionality claim, it was remanded back to the lower court to determine the substance of that matter. The second case, Fcfc Realty LLC versus Weiss. Petitioner made an application to the zoning board for variances and a special permit to construct a laundromat and retail space. Again, seeking both variances and the special permit related to this specific proposed use. After a public hearing, the zoning board denied all of the requested relief, and again, the petitioner, the applicant, appealed. One interesting issue that the applicant raised in this situation was that he claimed that his due process rights were violated because the zoning board accepted written comments from the public, but those members of the public weren't present at the public hearing to be quote unquote cross-examined by the applicant. And the court rejected this argument, explaining that while parties have a right to be heard by the board and present their position to the boards, it's not in the normal format that you would think of where you think of someone being cross-examined like in a trial. This is a quasi-legislative, quasi-administrative body, and the public hearings are more for informational purposes for the benefit of the board in order to be able to make their determination, and do not involve the receipt of sworn testimony in taking evidence. And so with respect to the standard for a special use permit, the court explained the distinction between a variance and a special use permit, which is an important one. Unlike a variance, which gives permission to an owner to use property in a manner inconsistent with a local zoning ordinance, a special exception or special use permit gives permission to use a property in a way that is consistent with the zoning ordinance, although not necessarily allowed as of right, which is similar to the prior case. In this case, despite that standard and the deference afforded to applicants for a special permit, the court did determine that the board had appropriately denied the special permit in these situations because the scope of what the applicant was proposing for the use, 112 washers and 90 dryers in the laundromat, was so expansive that it was going to increase the traffic and parking issues in the neighborhood to the detriment of the other property owners. And the other thing the court made clear is that an application cannot be denied based solely on generalized objections or community pressure. And even though in this case, there was significant community opposition to the application, there were other grounds that the court acknowledged, including the zoning board members' personal unique knowledge of the area being residents of the community that also supported the denial. So the next case is Marcus versus Planning Board of the Village of Wesley Hills. In 2010, an arborist obtained a special use permit and site plan approval from the planning board to operate a plant nursery and arborist business in a residential zoning district. Petitioner, a neighboring property owner, brought an Article 78 proceeding challenging the approvals, which were upheld by the lower court in 2017. So that was 7 years after he got his original approvals. I have no idea why it would take that long in an Article 78 proceeding, but for whatever reason it did. So after the lower court ruled in the property owner's favor that this use could continue, the neighbor appealed. And in this case, the court explained that because a special permit use has been found by the local legislative body to be appropriate in the zoning district and in harmony with the general zoning plan and will not adversely affect the neighborhood, again, if the proposal satisfies the criteria in the zoning code for a special permit use, it must be granted. But failure to meet any one condition in the code is sufficient basis to not deny the application. So in this case, what had happened was the planning board in considering, the planning board, in this case, it was the planning board, not the zoning board, that was considering the special permit use, One of the requirements for the arborist and nursery special permit use was that there be frontage and practical access on 2 main roads. Now, the planning board, when looking at this application for both special permit and site plan approval, probably looked at it from a practical perspective and said, based upon what they're proposing, where their property was located, there wasn't really a reason for them to require that the applicant comply with that requirement to have practical access to 2 major roads. And so they granted the special permit, even though he did not satisfy that condition. They did the same thing with the site plan approval, in that they granted the site plan approval, even though the application did not comply with the gross impervious surface ratio, which was almost double what the code permitted. So even though the planning board was trying to do a good thing and was trying to provide relief to this applicant under circumstances that they thought were reasonable, because the use did not comply with the strict requirements of the code in 2021, 11 years after the property owner first obtained its approvals, the appellate court said, you do not have a valid special permit and you do not have a valid site plan to operate your business. Now, from a practical perspective, what the property owner likely did was.
All right, excuse me, sorry to interrupt, Christie. Could you have control of the screen. Can you scroll up? We're still on the first page of the handout. Great. Thank you.
So from a practical perspective, as we saw in previous cases, the arborist likely made an application to the zoning board for variances from those requirements. But this is something that now has to be done 11 years after he got his approval. And if he doesn't get those variances, then the business that he's been operating is no longer going to be permitted to operate. And that's one of the scary things that you can see in land use cases, is that going through the litigation process, especially the appeals process, can take a long time. And sometimes you don't know what the ultimate outcome is going to be. And if it's not in your favor, it can really uproot everything that you've been relying upon. So the next case is Florida Historical Society versus Zoning Board of Appeals of the Village of Florida. The Historical Society was bequeathed title to 14-acre parcel that was previously used as a residential property. The Historical Society wanted to convert the building to a headquarters and meeting space and museum and create walking trails on the undeveloped portions. The Historical Society appealed to the zoning board from a determination that the proposed use was not a special permit use. In separate applications in both 2015 and 2016, the zoning board agreed with the determination that the proposed use was not a permitted special permit use. But the zoning board made the interpretation it's not a permitted special permit use, but then it actually granted conditional use variances for the Historical Society to operate this use on the property. But the condition was they had to obtain site plan approval from the planning board. And those approvals were granted in 2015 and 2016. So in 2017, they go to the planning board, and again, they get a conditional site plan approval. But this time it's conditioned upon the applicant providing a survey of the entire property, which they refused to do. So ultimately, the planning board denied the application for failure to comply with that condition. So now the applicant doesn't have anything because they didn't get the site plan approval, and their conditional use variances were based upon getting site plan approval. So they go to court and they try to challenge everything. And so the first issue is the statute of limitations to challenge the zoning board's determinations. And the court said it was far too late for that. Because the Historical Society had ultimately gotten the relief they needed, which was some form of authority from the zoning board in this case, in the form of a conditional use variance to operate on the property. At the time, they didn't see a need to challenge that approval, even though it also included an interpretation that it wasn't a special permit use. If it was a special permit use, they may not have necessarily been bound by that condition that was in the use variance. But by the time they realized that they had a problem years later because they hadn't gotten the planning board approval, the very short 30-day statute of limitations to challenge the zoning board approval had long since elapsed. And with respect to the planning board, the Historical Society also challenged that condition on the planning board approval to obtain a survey for the entire property. And this is an important point for a lot of planning boards when you're considering site plan approval. The court held a local planning board has broad discretion in conducting a site plan review and in setting appropriate conditions and safeguards in harmony with the general purposes and intent of the applicable zoning code. So here, the court found that there was a rational basis for the planning board to require that the applicant provide a survey, and it wasn't arbitrary and capricious, and therefore the court upheld it. So basically, by refusing to provide this survey for reasons that are not indicated in the decision, the Historical Society lost all of their approvals. And so the big takeaway from this case, and I try to emphasize it every time, is statute of limitations, because it's so short. And you may think something's not a problem at the time and that it'll be fine and it'll work out. But by the time you realize it's a problem, it may be too late. It's likely going to be too late. And so you really have to be very cognizant of what's in the decisions, what's in the approvals, and if there's anything that could present a problem. And then the last case, I believe, on site plan is Gershow Recycling of Riverhead versus Town of Riverhead. Petitioners purchased a property operating as a pre-existing non-conforming auto salvage facility. They submitted an application to the town planning and building department to do some site work, standard site work, drainage, regrading, putting in a retaining wall, concrete paving, and landscaping. The planning and building departments reviewed the application and determined these changes were de minimis and were exempt from site plan review under the code. A year later, after the work was done, they submitted an as-built plan showing what the property then looked like. And the town realized that it's substantially different from what had been presented. Basically, under the guise of their site work, the applicant had changed the use of the property from a legal non-conforming auto salvage facility to a recycling center, which was in no way legal on that property. So the planning and building commissioner then wrote to the petitioner and advised that he had the authority under the town code to render decisions on site plan applications, and that he had denied the application on the grounds that the use was not permitted. The commissioner then advised the petitioner that they could appeal to the ZBA. The petitioner did not go to the ZBA and instead went straight to court in an Article 78 proceeding, challenging the commissioner's determination to deny site plan approval. While the court doesn't specifically address the merits of the argument, basically whether site plan approval should have been granted or denied, or whether the recycling center is a permitted use or not, what the court did say, and frankly, the petitioner applicant would likely be hard pressed to make those arguments. What the court looked at more and what the applicant focused on was the procedure rather than the substance. And in that respect, the court did agree with the applicant. So in this situation, the court determined that the commissioner did not have authority under state law or the town code to amend the site plan application. Under New York Town Law 274A, the town board has the authority to charge the planning board or another administrative body with hearing and deciding site plan applications. In this case, the town board, through enacting a local law in the town code, did delegate that authority to the planning board to review and approve with modifications, or disapprove site plans. Therefore, while under the code, the commissioner did have certain authority with respect to site plans, such as to make determinations regarding a site plan application's compliance with the zoning code, the commissioner did not have the authority to outright deny the application himself. And because the commissioner exceeded his authority in denying the site plan application, petitioner was not required to exhaust his administrative remedies by appealing the determination to the zoning board first. And we'll talk about a case specifically related to exhaustion in a little bit. Instead, the court sent the matter back to the planning board to make a determination on the amended site plan application, which is where the petitioner had started 7.5 years earlier. Area variances. So we did kind of tangentially touch upon area variances a little bit, and we'll get into the standards for this as well. So the first two cases, O'Connor and Estate of Stelling, what's interesting about these two cases is that they address similar applications, but the outcomes are completely different. And it goes to show how fact-based these determinations are and how important it is for the board to have a record and facts that supports its determination. So in O'Connor and Sons Home Improvement LLC versus Acevedo, petitioners had a vacant lot and sought to subdivide it into 2 lots and to put a house on each lot. However, the size of the proposed subdivided lots was less than the minimum lot size and therefore required area variances, which the zoning board denied. The court started its analysis by explaining the deferential review afforded to zoning boards. And I'm going to quote for a second. Local zoning boards have broad discretion in considering applications for area variances. Courts may set aside a zoning board determination only where the record reveals that the board acted illegally, arbitrarily, or abused its discretion, or that it merely succumbed to generalized community pressure. And then after saying all of those deferential things about zoning boards, the court then overturned the ZBA's denial for basically doing exactly all of the things that the court said they're not supposed to do. So the court found that the ZBA's decision was supported by insufficient conclusory findings. The court noted that while scientific or expert testimony is not always required to support a ZBA's determination, in this case, expert testimony had been submitted by petitioners, and the ZBA did not rely upon its own expert testimony to counter that evidence, and instead relied solely upon generalized community opposition, which you really can't do. In addition, an issue that often comes up and that we talk about is precedent. And in this case, the court found that the zoning board had set a precedent in previously approving a different application on essentially the same facts. Now, what I've said before, and the standard continues to be, you're not necessarily bound by prior precedent, but you have to distinguish it. You have to justify it. You have to have a substantive, reasonable explanation for deviating from that prior decision. And that's why we talk a lot about making sure you have a record, making sure your determination is supported by facts so that it can be distinguished in the future. And so in this case, the court didn't even specifically address the area variance criteria and just threw out the zoning board's decision. In contrast, in the estate of Stelling versus Godioso, petitioner again owned a 16 square foot lot with a single family home in a district where the minimum lot size was 20,000 square feet. So even as one lot, it was undersized. Petitioner proposed to subdivide the lot into 2 lots and construct another house on the vacant lot. The lots were proposed to be 6,000 square feet and 10,000 square feet in a district where 20,000 square feet is the minimum, which would make this a 50% and 70% variances respectively. Petitioner also informed the board that if they were able to subdivide and construct the second house, they intended to sell them both. So before analyzing the ZBA's actions, the court went through the variance criteria, which I'll just briefly state for the audience's edification. It's a balancing test weighing the benefit of the applicant against the detriment to the health, safety, and welfare of the neighborhood. And in making that determination, the zoning board must consider the following factors: whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the area variance, whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance, whether the requested area variance is substantial, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood or district, and whether the alleged difficulty is self-created, which is a relevant consideration but not determinative. And this is a balancing test. So the applicant and the board don't have to demonstrate satisfaction with every single one of these criteria, just a weighing of the different factors in determining whether or not it balances in favor of approval or denial. So in this case, the court held that the zoning board had properly considered the area variance criteria in denying the application. The court noted there was evidence in the record to support that the variances were substantial, 50% and 70%, as I said earlier, and that there were feasible alternatives, namely leaving the parcel in its current condition as one lot. On the next case is Capitola versus Town of Riverhead. Hocker, who was the applicant, wanted to construct a single family home on a vacant parcel. The building department determined 4 area variants were required, 1 for impervious coverage and 3 setback variances. Petitioner was a neighboring property owner and appeared at the zoning board public hearing in objection to the application, and also argued that in addition to the 4 variances Hocker was seeking, he also needed a lot size variance. Ultimately, the zoning board approved the 4 area variances and determined a lot size variance was not needed. Petitioners brought an article, the neighbors brought an Article 78 proceeding challenging that approval. The court ultimately upheld the granting of the variances, finding the zoning board did engage in the requisite balancing test and considered the relevant factors. In addition, While it appears the court may have actually agreed with petitioners that the ZBA was wrong in finding a lot area variance was not necessary, the court put the petitioners in their place essentially and said that any error by the zoning board on this point did not require sending the application back to the zoning board for a new determination because the issue was never properly before the zoning board. And the reason for that is that the zoning board's jurisdiction is appellate only, unless it's specifically authorized by the code to grant other approvals, for instance, sometimes special permits. But in general instances, it's only appellate, and it only has jurisdiction to review a determination that has been made by the administrative official charged with interpreting the zoning code and appeal to them. In this case, that was the denial letter by the building inspector that identified the 4 variances that were needed. There was no determination by the building inspector that a lot size variance was required. But even if one could interpret the building inspector's determination that the omission of the lot size variance from that determination meant it was not required, then the onus was on the petitioners to challenge it to the zoning board themselves. Instead, the petitioners just appeared in opposition to the applicant's application and raised it in opposition, but that was not sufficient to put the issue in front of the zoning board in order to make a decision. So while the zoning board may have been wrong and a lot area variance was actually needed, it was never actually properly presented to them, and therefore it did not require it to be sent back to the zoning board. We'll just go through use variances. There's only 2 cases for this. There really haven't been a lot of use variance cases lately. I think maybe that's because they're so hard to get that people often don't try and generally may go the route of trying to get a rezoning or some zone text amendment instead. But I do think it's an important principle. So I found a case that's kind of tangentially related, and I'm just going to inject the criteria for everyone's benefit at the start. So unlike an area variance where it's a balancing test and you don't have to satisfy all the criteria, a use variance, you do have to satisfy all the criteria, and it's much harder criteria to satisfy. And the reason for this is because a use variance is essentially asking the board to let you use your property for a use that's not determined to be appropriate for that location in the municipality. So the criteria for a use variance is, first, the applicant cannot realize a reasonable return if the property is used for any use permitted under the current zoning, which proof must be through competent evidence or dollars and cents proof. So essentially this means a property owner doesn't have the right to the highest and best return of their property if it's not permitted under zoning, just a reasonable return. And you have to show that you wouldn't be able to get that reasonable return through any use of the property that's permitted in the code. And you have to demonstrate that through an actual financial analysis, which is where most applicants generally get hung up. And so it's rare that you actually see cases that address all of the criteria. The second of which is that the hardship results from unique characteristics of the property. Namely, the board wants to know, and statute requires, that other property owners aren't going to be able to rely upon this situation or the potential precedent it would set to get a similar variance for their property. Third, the proposed use would not alter the essential character of the neighborhood. And fourth, that the hardship has not been self-created. And while the hardship being self-created is a factor to consider in area variances, but the statute expressly says it's not determinative, for use variance, it absolutely is determinative. And often that's a difficult standard for applicants to satisfy as well. So the first case is Viteri versus Zoning Board of Appeals of the Town of Kent. And these are actually 2 related cases.
You could just scroll down a little.
Yes, sorry. So in Viteri, a commercial property had been used as a concrete batch plant since at least 1949. Pursuant to the zoning code that was enacted in 1937, the property could not be used for manufacturing products like concrete unless certain conditions were met, including that fewer than 5 employees were engaged in such work. However, the property had been granted a variance from the ZBA in 1948 before it started operating in 1949 that allowed the then owner to employ more than 5 people in the operation of the concrete plant. Kent investors purchased this property in 2016 and intended to refurbish the building and continue the concrete plant operations. In 2017, the building inspector determined that the use was no longer allowed because he believed the use was a pre-existing non-conforming use. And because the use had lapsed for an extended period of time, the use was no longer permitted. And I think we have one other pre-existing non-conforming use issue that'll come up, but just to briefly address that point, is that this is a pretty standard concept. So if you have a pre-existing non-conforming use, it's a use that's not permitted by the code, but the use has been existing since before it wasn't permitted by the code. And in most of those instances, the use is allowed to continue as long as it's used for that purpose continuously. However, most codes do have what's called a lapse provision or a ceasing provision. So if the use stops for, and it varies by code, it could be 6 months, it could be a year, it could be longer. But if it stops for that period of time, then the pre-existing non-conforming use is considered to cease, and any further use of the property has to comply with the code. So basically, it doesn't say in this case how long the use had ceased or what the lapse time was, but presumably it was for a while because the building inspector determined that his belief was that it was pre-existing non-conforming, and because the use had lapsed, it could no longer be used for that purpose as a concrete plant and could only be used for permitted purposes. So after the building inspector made this determination, Kent, who was the applicant, went looking through the file and found this 1948 variance that allowed the use of the property for the concrete plant with more than 5 employees. And so he argued that this was a use variance that ran with the land, meaning that it wasn't specific to one property owner, but that it allowed this use on the property under the circumstances set forth in the variance in perpetuity, as opposed to, as I was saying earlier, with the non-conforming use, where if it stops, then it can't, a pre-existing non-conforming use, then if it stops, it can't continue again. The building inspector maintained his position that it was a lapsed legal non-conforming use. And so Kent applied to the zoning board, appealing to the zoning board and seeking an interpretation that this 1948 variance was a use variance and that allowed him to restart the concrete plant operations. And the zoning board actually agreed. And they said it was a use variance, it gives you this authority, so go ahead and continue operating. So 2 sets of neighboring property owners, Viteri, who's the named petitioner, and Hill and Dale, which is a corporate entity, brought separate Article 78 proceedings challenging the zoning board's determination. And the first thing the petitioners argued was about the record. In an Article 78 proceeding, the court's review is limited to what's in the record that was before the board, and it's the responsibility of the board when they put in their answer to the Article 78 proceeding to also provide the certified record of what was before them in making their decision. And the reason for this is that the court can't determine if the board's decision was arbitrary and capricious or if it had a rational basis if the court is looking at information that the zoning board didn't have. And so that's why the court's review is limited to what was in the record that was before the zoning board. In this case, petitioners wanted the zoning board to include in the record an appeal from a prior determination of the building inspector in 1998, so about 20 years earlier, not the one at issue in this case. And the court said no, because that issue was not before the zoning board, it wasn't presented to the zoning board, the petitioners hadn't submitted it to the zoning board and put it in the record, there was no basis for that to be in the record that the court considered, because then the court would be considering information the zoning board didn't have. What the lower court had done is the lower court hadn't actually considered this issue of the use variance on the merits, because it determined that the petitioners did not have standing. And so when the appeals court looked at this, they said, you know what, I think that's wrong. We think the petitioners do have standing. And the reason why they said that is because they found that the alleged injuries that were claimed by petitioners were different from those suffered by the public at large. And those injuries fell within the zone of interest protected by the town zoning laws. Specifically, petitioner Hill and Dale owned a lake directly across from the subject property and alleged interference with their ability to enjoy recreational activities around the lake and impacts to their properties from increased noise, traffic, dust, and pollutants. So the court found that that was sufficient to confer standing to Hill and Dale. But because the lower court hadn't actually considered the issue on the merits because it threw it out on standing, the court had to remand the issue back to the lower court to determine whether the zoning board had actually properly ruled that it was a use variance that could allow the use to continue. So it's probably back in the lower courts right now, and maybe we'll be seeing another appeal on this in another 2 to 3 to 4 years. And the next case, which is, like I said, related to the Viteri case, is Titan Concrete Inc. versus Town of Kent. So as I mentioned in the Viteri case, one of the petitioners challenging the zoning board's determination was Hill and Dale, a corporate entity. And as it turns out, one of the members of Hill and Dale was the town supervisor of the town of Kent. So after the zoning board issued its interpretation that the concrete plant could continue to operate under the 1948 use variance, the town board decided to take action of its own. The town board adopted a local law that prohibited the production and manufacturing of concrete and the operation of concrete products plants in all zoning districts except one. And that one zoning district where it continued to be allowed was an industrial district and not where Kent's property was located. The law provided that anyone that was lawfully operating such a use could continue to do so for 2 years, kind of like a sunset provision, at which point the use would be prohibited unless the zoning board decided to extend the time that it could be used for an additional limited period of time. So if the applicant could show a necessity to recoup their investment on this use of the property. So, and I'm going to talk a little bit more about this later, but the standard for review in a legislative board adopting a local law is very deferential to the legislative board. And there's a very strong presumption of validity. And so it would have been very difficult for Kent, the property owner, to have this law overruled. So what Kent did was they went a different route and they claimed that the entire process was tainted and the law was invalid due to the supervisor's conflict, and the court agreed. So the court explained that conflict of interest issues require a case-by-case examination of the facts and circumstances. So you can't have hard and fast rules when it comes to a conflict of interest. You have to look at the specific circumstances. And the court explained that the relevant question is whether the official had any direct or indirect, pecuniary or otherwise, in a project such that their vote could reasonably be interpreted as potentially benefiting themselves. The test to be applied is not whether there is a conflict, but whether there might be. And in this case, given the supervisor's membership in this entity that had challenged the approvals, there was no question that the supervisor had a conflict, and even she acknowledged it. But what happened was the supervisor did acknowledge the conflict and recused herself from voting on the local law, but didn't recuse herself from the entire process. She continued to preside over the public hearings on the local law. She engaged in discussions with the property owner and the public. She attended executive sessions with the town board to discuss the issue and voted on certain motions related to the local law. And so under these circumstances, the court held that the supervisor's involvement in the process, given the conflict, did taint the law's enactment and rendered it invalid. So that's a pretty harsh reality, given that the supervisor did not vote. But I guess given the extent to which there was an interest in it, or a perceived interest, the court found it was too much to ignore. Adam, do we want to stop for questions, or do you want to give a code word or something?
Thank you. Yes. All right. We will do our second code word. Again, this is just for attorneys looking for CLE credit. And the second code word is Palisades, as in the parkway or the stadium or the region, Palisades. And I'm a little surprised I am not seeing any open questions. If anyone has them, I would just also, please just use the Q&A. It's a little tough to try to bounce back and forth between Q&A and chat. So if you do have a question, please put in the Q&A, but right now I'm not seeing any.
Okay, I'm happy to keep going.
All right, sounds good. Thank you.
Okay, so I will scroll down. Okay, so like I said earlier, it's kind of hard to categorize these cases because they all deal with so many issues. But I did try to just pull out a few that we've already talked about standing a little bit, and we'll talk about it more in the context of SECRA. But I did pull out just some concepts that I thought were a little bit different or that came up in this round of cases. So the first, and this, and interestingly enough, what I've seen a lot of this time around and in these next two cases is that they're again related. So one came after the other, but the courts decided them on the same day and released them together. So the first case is Greenville Fire District versus Zoning Board of Appeals of the Town of Greenberg. So Formation Shelburne is made an application to the Town of Greenberg to construct an assisted living facility. The application required area variances from the zoning board and a special permit from the town board. The zoning board served as lead agency pursuant to SECRA, which we'll talk about more in a little bit. And I know it can be hard to follow the dates, but I did put some of them in the handout, but it is important in a situation like this, especially when you're dealing with statute of limitations. So the zoning board granted the variances, issued the condition negative declaration, which for all intents and purposes did end the SECRA process in April 2017, and granted the area variances on June 22nd, 2017. After the area variances were granted on June 27th, 2017, the results of the June 22nd meeting, the determination and the vote of each of the board members was filed with the town clerk. Then on July 13th, 2017, the ZBA filed a formal certification of the decision, which set forth the substantive findings of the zoning board in granting the variances. So what the petitioner did, the Greenville Fire District did, was they used the July 13th, 2017 date when the zoning board filed the certification of the decision as the start of the 30-day statute of limitations to bring their Article 78 proceeding challenging these approvals, which frankly does make sense because that was what set forth the substantive basis for the decision and what the petitioner was going to have to dispute in bringing the Article 78 proceeding. But the court said no. The court said what you were actually supposed to challenge was started on June 27th when the actual results, which was how the board voted and the vote of each board member, was filed with the town clerk on June 27th. Now, who knows if the petitioner even knew that that was filed, but because that was the first filing, that was a decision that reflected the decision of the board, that was what started their 30-day statute of limitations. And so because they initiated their Article 78 proceeding on August 11th, which was more than 30 days after that initial recording of the decision had been filed, the statute of limitations had run and the court could not. It's a jurisdictional matter. So the court doesn't really have discretion to say, oh, well, I feel bad for you, or I can see how you could get mixed up in that, or, it's a really short statute of limitations. There's no discretion there. And the court has to follow it. So you have to be really careful with that. So the court threw out the claim challenging the zoning board's decision to grant the area variances without considering the merits of the application. And so now to back up to the secret determination, the condition neg deck that had been issued in April of 2017, the court said that this is also subject to a 30-day time frame to initiate the proceeding, but the time to challenge a secret determination does not start until there is a decision that renders final the consideration of secret issues. So the issuance of the condition neg deck did not start the clock because that action in and of itself did not constitute an approval that would allow the process to go forward. But once the zoning board granted the variances, that was the first approval granted in furtherance of the secret determination. And that started the time to challenge the secret determination. So the time to challenge the secret determination was then linked to the time to challenge the zoning board determination. And because the zoning board determination wasn't challenged in a timely manner, but by default, the secret determination also wasn't challenged in a timely manner. So both of those petitions and claims challenging both determinations got thrown out by the court without considering the merits of either one of them. And then the next case, again, Greenville Fire District versus Town Board of the Town of Greenberg. And in this case, as I mentioned earlier, in addition to needing area variances from the zoning board, the applicant also needed a special permit from the town board, which was granted the following February 2018. The petitioner, Greenville Fire District, did also challenge this decision, And in this case, there was no question that they did it within 30 days and they did it in a timely manner, probably because they had seen what the town had said with respect to their first action. And so they knew what they had to do. But in this case, they also again tried to challenge the condition negative declaration, even though the zoning board determination had been made several months earlier. And in this case, the court rejected that challenge to the secret determination on the basis of res judicata. So basically that means that res judicata precludes a party from litigating a claim where a judgment on the merits exists from a prior action between the same parties involving the same subject matter. This rule also applies to claims that could have been raised in the prior litigation. So the fact that petitioners could have raised the secret issue in the prior litigation and did, but it was thrown out because it wasn't timely brought, that was considered a determination on the merits, and therefore they were no longer permitted to challenge it in any subsequent action. But we still had the issue with the town board special permit. And like I said earlier, there was no question that was timely. So the court had to look at that challenge, that claim, and see if it had any merit. But again, the court decided not to get to the merits of the case, and in this situation, threw it out on standing. So what the court said was the fire district raised a number of concerns. And one of them was the concerns regarding increased calls for emergency services during construction and the need to provide additional personnel and equipment to adequately provide those services. And the court said they're not within the zone of interest intended to be protected by the zoning code. So the courts basically said, short-term risks related to construction and fire protection services is not something the zoning code is looking at. It could very well have been something SECRA was looking at, but again, the challenges to the SECRA determination were thrown out. So we were only looking, when you look at standing, you have to look at what you're challenging, and you have to show how you are within the zone of interest of the law that's intended to be protected by the law. And in this case, the court said that the zoning code and the provisions for a special permit were not intended to protect the fire district from the risk of increased calls or the need to increase their personnel and equipment. So after all of that, the court never heard on the merits any of these challenges regarding the town's determinations. And then the last case, which I alluded to a little bit earlier, is exhaustion of administrative remedies. 505 Northern Boulevard LLC versus Incorporated Village of Old Brookville. Petitioner had submitted a building permit application to operate a gas station on his property. The building inspector denied the application on the grounds that the gas station use was again legal non-conforming, but then it had been abandoned under the zoning code. And I was able to look up this zoning code provision, and it provides that any pre-existing non-conforming use discontinued for a period of 1 year shall not be reestablished. And petitioner brought in Article 78 from challenging the building inspector's determination. In this case, the court explained it's Hornbook law, which basically means it's a basic concept that one who objects to the act of an administrative agency must exhaust available administrative remedies before being permitted to litigate in a court of law. In this case, that meant petitioner should have appealed the building inspector's determination to the zoning board, which could have provided petitioner with the relief he was seeking before going to court. It also would have allowed them to put together a record as to the basis for the determination, because right now, all we had was the building permit application the applicant submitted, and then the building permit denial from the building inspector. So the zoning board, if they had heard this application, there likely would have been a more robust record put together that would have given the court some more insight. And again, part of the reason why you exhaust administrative remedies is because if the zoning board could have granted the relief that the applicant was seeking, namely an interpretation finding that the use hadn't lapsed, then there would have been no need to go to court. But the court recognized that unlike statute of limitations, the exhaustion of administrative remedies rule is not hard and fast. There are certain exceptions to that rule. such as when the action being challenged is unconstitutional or wholly beyond its granted power, like we saw earlier with the case where the building inspector denied a site plan application without the authority to do so, or when the administrative remedy would be futile or pursuing it would cause irreparable injury. In this case, the only argument that the petitioner made regarding to the exceptions to the exhaustion rule was that petitioner claimed that the building inspector's denial was essentially an unconstitutional taking of his property. And the courts basically said, nice try, but no. You can't just say constitution to get out of exhausting your administrative remedies. There has to be a basis for it, and it has to be a legitimate basis. And in this case, there really wasn't much there, partially because there was no record that had been adduced before the zoning board in order to establish whether there was any merit to that. So the court found that there were no applicable exemptions to the exhaustion rule and declined to hear the case on the merits. I guess I'll go into secret. So the first case is a quick one. Capitola versus Town Board of the Town of Brookhaven. I just threw this in for the principle of type 2 actions. Petitioners commenced a proceeding to challenge the town board's determination that the town's proposed condemnation of an easement by eminent domain was a type 2 action under SECRA, which is exempt from environmental review. Petitioners argue that the project would have a significant effect on environmental conditions and that the type 2 classification was improper. The court upheld the town board's determination of a type 2 action, and as a result concluded the town had no further responsibilities to conduct an environmental review. So what is a type 2 action? Very quickly. The DEC promulgates regulations with respect to SECRA. It has a type 1 list and a type 2 list. And type 2 lists are a list of actions that the DEC has determined pretty much as a matter of law are not going to have significant adverse environmental impacts and therefore are not subject to SECRA review. So even if you could have a circumstance where based upon other circumstances or situations, there could be an adverse environmental impact, like in this case, you know, what petitioners were saying could be true. There could be other issues related to this that could be adverse to the environment. But because this action was listed on the type 2 list and the court found that that was a proper typing of the action by the town board, there was no need for any further environmental review regardless of those other circumstances. So the next case is Peachin versus City of Oneonta. And in this case, Parkview had submitted a proposal to the City Planning Commission to construct a 74,000 square foot, 4-story mixed-use building. The development would include 64 affordable housing units marketed to local artists and middle-income residents. It also included construction of an educational facility developed in conjunction with Hartwood College, which was a local college, to provide testing, product development, and support resources for local grain industry professionals. The proposed project site was a 2.1 acre parcel with an existing municipal parking lot, and the project was anticipated to cover less than 1 acre of that parking lot. Unlike the prior case, in this case, the planning board determined that this was a type 1 action, which would, because it was adjacent to a nationally listed historic property. So unlike with type 2 actions that are presumed not to have any significant adverse environmental impacts, a type 1 action is a separate list that does carry with it the presumption, albeit a rebuttable presumption, that there is the potential that the project will have at least one significant adverse environmental impact and require the preparation of an environmental impact statement. But again, that's rebuttable, and it's not a hard and fast rule that if it's type 1 action, an EIS is required. And that's what happened in this case. Even though it was a type 1 action, after going through the SECRA review process, the planning board did issue a negative declaration determining there was not the potential for any significant adverse environmental impacts, and which ended the SECRA process. The planning board then granted site plan approval and also waived some of the parking requirements based upon the parking that was going to be lost in the municipal lot for this development, as well as some of the additional parking that was going to be required for this development, but could not be provided on site. So that those parking variances were a little substantial. But the planning board had the authority to waive them and did decide to under these circumstances. And after the planning board granted that approval, the city entered into a purchase and sale agreement conveying the parking lot parcel to the applicant Parkview. So petitioners who were nearby business owners challenged the planning board actions and the conveyance of the property. The court upheld the lower court's determination that the petitioners lacked standing. In order, as I mentioned a little bit earlier, in order to establish standing under SECRA, the petitioner must show that they have suffered an injury in fact, and that the injury was within the zone of interest intended to be protected by the statute. Because SECRA is intended to address and protect environmental considerations, the alleged injury has to be environmental. In this case, what the petitioners were basically arguing was the economic impacts to their businesses from losing all of that parking in the municipal lot that was going to be converted to this development for the affordable housing and the educational and research uses for Harwood College. In addition, the harm also has to be different from the public at large. So for instance, where the petitioners argue that they would be harmed by traffic impacts, that's something that anyone anywhere could have argued. And so the court said that that was not a sufficiently distinct injury to these petitioners to afford them standing to bring these claims. The petitioners had also alleged harm from the obstruction of scenic views from the development. And the court acknowledged, you know what, that could be a basis for standing because SECRA looks at environmental impacts like aesthetics and views and scenic views specifically. And it's definitely within the zone of interest of what SECRA is intended to protect. But they didn't do a good enough job of laying out what those alleged harms were. They were too undeveloped and speculative. And so the court said that doesn't confer standing either. So they had three different bases. They had economics, they had the visual impacts, and they had traffic. And the court found none of that satisfied the standards for standing. However, the court then did go on to address the merits of the case, which I did think was interesting, because they could have just done what happened in the prior cases and just stopped once they found a threshold issue and not gone any further. But in this case, the courts did look at the substance of the SECRA claims, and the standard is whether the Planning Commission took the requisite hard look at the potential impacts and made a reasoned elaboration for the basis of its decision. The court found that the Planning Commission did so with respect to the parking impacts because they relied upon a parking study from an independent consulting firm that identified ample parking available in the district. And the court noted that there were two other projects contemplated in that area that had never come to fruition. And therefore there was additional parking that had been contemplated for use by those developments that could also be used by this development. So the court was satisfied that based upon the parking study and looking at the area as a whole, that the Planning Commission had taken a hard look and provided a reasoned elaboration for its justification that there wouldn't be any significant adverse impacts. The other issue that the petitioners raised was that the conveyance of the property and the proposed use of the property violated the public trust doctrine. And the reason for this was because, as I said earlier, or I don't think I did, sorry. I said it in another case. This property had been bequeathed to the city in 1922 with the uses to be limited to public buildings and for park and municipal purposes. So where a municipality acquires public property with the direction that it only be used for public purposes, that the municipality can't divert that property away from into either a possession or use that's exclusively private without approval from the legislature. However, if the property continues to serve a public function, there is no violation of the doctrine. And the court found here that there was not a violation of the public trust doctrine because the property was going to be providing affordable housing that was part of the city's downtown revitalization initiative. And because of the collaboration with Hartwood College for educational and research purposes, the property would continue to serve a public use, and so it didn't violate the public trust doctrine. So the next case is Hart versus Town of Gilderland, and we're going to be in another situation where this case and the following case, Save the Pine Bush, are related. So from 2015 to 2018, the town had explored potential development options in an area of the town that had an existing mall, a nature preserve, and a historic district. A lot of different moving parts there. And they ultimately adopted a local law creating a transit-oriented development district in this area. After putting that zoning in place, they were presented with two different proposals. The first one earlier and the second one a little bit after, on two separate parcels. And the first one was a 222 unit residential development on one site, site one. And the other was 160,000 square foot retail that was going to be a Costco and gas station development on site two. So the planning board, because they were going to be happening around the same time, looked at these two projects together and looked at the cumulative potential impacts and determined that there was the potential for at least one significant adverse environmental impact. And so the planning board did issue a positive declaration, which does not end the secret process, but instead requires the preparation of an environmental impact statement. And I'm going to use this case as an opportunity to just run through with you what that process looks like. So after the positive declaration is issued, the planning board engaged in a public scoping process, which is to create the outline of the environmental issues to be addressed in the draft environmental impact statement. So it's basically the table of contents for what is going to become this big substantive book that's going to contain analysis of any environmental issues that could potentially be adversely impacted by this project. It could be traffic, it could be stormwater, it could be historical resources, geological resources, municipal resources, whatever's applicable in that specific situation. So they did prepare the scope with the input from the public, and the applicant prepared the draft environmental impact statement and submitted it to the planning board. The planning board accepted the DEIS as complete, not necessarily saying that they agreed with everything that was in it, but that it substantively addressed everything that was required to be addressed based upon the scope. And then the planning board held a public hearing and received ample written comments on the DEIS. The applicant then prepared a final environmental impact statement, which basically addresses all of the substantive comments that were raised during the public hearing process on the DEIS. After the FEIS was complete, the planning board issued finding statement authorizing the projects to go forward and ending the secret process. Once the secret process was complete, the planning board granted site plan approval. Town residents and business owners challenged the secret process and determination, which the lower court actually agreed with the petitioners and the lower court vacated the finding statement and the site plan approval, and the developers in the town appealed. So the first issue that was raised was another twist on a standing issue. In this case, the petitioners, who were town residents and businesses, said that they don't get into the specifics of it, but basically they said that it was improper for the planning board to serve as lead agency for a coordinated secret review. A coordinated secret review being one agency that has decision-making authority conducts the environmental review on behalf of all of the agencies that will have decision-making authority. And in a type 2 action like this one is, it's required that it be a coordinated secret review. But the court said that the only entity or agency that would have standing to challenge the planning board's determination or action to be lead agency under secret would have been another involved agency, another agency with discretionary decision-making authority that could have been lead agency themselves. And because these residents and business owners did not have that type of authority and could not have been a lead agency, they did not have standing to challenge that. So then the court went through the secret standard, which I mentioned earlier, And it is for a substantive seeker review. It's to look at the relevant areas of environmental concern and determine whether the planning board took a hard look at them and made a reasoned elaboration on the basis for its decision. In further explaining the court's scope of review, the court noted an agency's substantive obligation under SECRA must be viewed in light of a rule of reason, as not every conceivable environmental impact, mitigating measure, or alternative must be identified or addressed to satisfy the substantive requirements of SECRA. And then the last thing the court said, well, it's not literally the last thing the court said, but the last principle the court mentioned, which actually became a continuing theme throughout this case and this decision, was that it is not the province of the courts to second guess thoughtful agency decision-making. And accordingly, an agency decision should be annulled only if it is arbitrary, capricious, or unsupported by the evidence. So the court was reminded us in this case multiple times, it's not my job to make the planning board's decision for them, even though the court wouldn't come out and say it, but the rationale is, even if the court disagrees, even if the court on its own would have decided separately a different conclusion, that's not the court's standard of review. The court has to look at the record and determine whether the planning board took a hard look and made a reasoned elaboration for the determinations that it made. And if it did, then it has to be upheld. And under that standard, which it's unclear if the lower court followed that standard as well in vacating the SECRA findings, but in this case, the appellate court upheld it. And the court went point by point through the environmental areas that the petitioners had claimed the planning board didn't take a hard look at. And based upon the evidence in the record and the planning board's reasoning, determining the planning board had in fact taken a hard look at these issues. And I'm not going to go through these nearly as in depth as the court did, but I just do want to give you a flavor for what the court looked at and what the court said. It went, that's enough. Based upon what you have in the record, you've satisfied your hard look standard. So with respect to impacts on the avian population, the court relied in part upon reports from the DEC and the planning board's environmental consultants finding no avian species of concern were utilizing the sites. With respect to visual impacts to the historic district, it was a historic residential district. The court noted the currently existing 200-foot buffer from the historic district, existing mature vegetation, and the distance between the site and the closest house in the historic district was nearly 1,000 feet. And the court found that that was sufficient to justify that there wouldn't be any visual impacts to the historic district. With respect to community character, the court looked at the planning board's goals that the planning board looked at the goals of the transit-oriented district that the town board had adopted. And even though the proposed Costco did not comply with all of those goals, the court found that that was not a basis to deny the project or that the planning board didn't take a hard look, because the goals were so diverse and all over the place that it would have been literally impossible for any project to really comply with all of those diverse goals that the town board wanted to see. And the court reminded us again that it's not the court's purview to try to find that perfect use. And lastly, with respect to alternatives, which is a required analysis under an environmental impact statement, including you have to look at a no action alternative. So in an environmental impact statement, you have to consider alternatives, including the possibility that nothing happens and the property just stays the way it was, in contemplating what the best way to move forward with the project is. And the court explained the lead agency is not required to engage in an exhaustive analysis of every conceivable alternative. The court also recognizes that SECRA protects the right of a developer to advance its own business objectives and mandates that a review board should only consider alternatives consistent with those objectives. So here, where one of the applicants was proposing a Costco, it wouldn't have made sense to ask him to look at either other parcels that couldn't feasibly have a Costco or didn't make sense under those circumstances or weren't available for sale or lease or something like that. And it also wasn't reasonable to ask them to look at putting an office building or putting residential or putting something that's completely beyond the scope what they're proposing with this retail development. So the alternatives have to be realistically feasible in the context of what the application is. And with that context, the court did go through the detailed analysis of the alternatives the planning board considered, and again found that they did take the requisite hard look at the anticipated adverse impacts and provided a reasoned elaboration for its basis for approving the project, including the remedial measures to be employed to mitigate adverse impacts. So the court ultimately reversed the lower court and found that the planning board's determinations were proper. And then in the next case, Save the Pine Bush versus Town of Gilderland. So this was a different set of petitioners who separately filed an Article 78 proceeding challenging the seeker review and the site plan approval after the Hart petitioners did. The lower court dismissed that proceeding on the grounds that its decision of Hart was wholly dispositive of all secret issues raised by these Save the Pine Bush petitioners. The appellate court again disagreed with the lower court and said, no, it's not entirely dispositive. And the petitioners aren't prohibited from bringing their own action or proceeding challenging these issues because they weren't a party to the other proceeding and they weren't in privity with the other petitioners, meaning they weren't related to them and they didn't share the exact same interests. But just because the petitioners could bring this proceeding doesn't mean that the court is going to review the issues from scratch or de novo, because it had previously made its determination in the Hart case that the secret review was proper. So the court explained that the holding that a sufficient environmental review had been conducted was binding under the principles of stare decisis, which is legal precedent, which is similar to the precedent we talk about in zoning, except it's a little bit more stringent in case law. Legal precedent is a very important thing. You may have heard about it on the news lately. Anyway, so petitioners would have to give compelling reasons to depart from that precedent. So what petitioners did in an attempt to provide those compelling reasons was they raised flaws with the secret process that were not raised in the Hart litigation. Basically, they raised different potential environmental issues with respect to fauna, pesticides, air quality, and wetlands. And as in Hart, the court went and analyzed each issue and noted in the record how the planning board addressed them before concluding that the planning board took a hard look at the potential environmental impacts. Therefore, the court determined that there was no compelling basis to deviate from its ruling in Hart that the secret review process was sufficient. And I just there were a couple of procedural issues that these petitioners raised. I guess try to throw everything in there and hope something sticks. And this first one is something that we're probably going to be seeing for a while. This is the first go around of doing these lectures where I've seen it come up. But what the issue is procedurally, whether public hearings were held properly, whether there were violations of open meetings law in light of COVID-19 and the modifications that were made to how municipal boards conduct their meetings under those circumstances, which are still in effect. So in I think there were 2 or 3 cases where, especially in cases where you have a high interest of the public and you have a lot of public trying to attend and observe these meetings, especially early on in the pandemic, there are technical issues. It happens, you can't really avoid it. So in this situation, apparently, during the public hearing on the site plan, it was held remotely, and there were technical issues that prevented the first 20 minutes of the hearing from being live streamed. The court noted that the video was available in real time on public access channels, and the entire video was later posted on the town's website. And people who weren't able to call in during those 20 minutes to participate in the public hearing process were able to call back in and participate. Therefore, even though looking at a black and white strict reading of the law, there was a violation of the open meetings law for those first 20 minutes because the public wasn't able to attend and observe the proceedings. It was an unintentional and technical one that did not provide good cause to annul the planning board's determination. And then the last issue petitioners raised, which I don't really think they thought they had a chance on, but I think it's important for boards to understand, if you don't already, how this works. The planning board in this case was a 7-member board, and petitioner claims that because one of the members had resigned, the actions of the board were invalid. That is not the case. The rule is that a board can act unless there's a special circumstance where the board has to act by something other than a simple majority. The general rule is that a board can act by majority of the total number of members of the board, right? So if this was a 7-member board, even though one member had resigned, you still need that majority of 7 members. It's really 6 in one hand, half a dozen in the other, because 7 or 6, you still need 4 to have a majority, but that applies when you have different numbers as well. So for instance, if you have a 5-member board and 2 members are absent, you can still vote and have an approval or a formal action with 3 members. You just need all the 3 of those members to vote in favor of that application. So it's not having a majority of the members present, it's having a majority of the total compilation of the board. And so in this case, where all 6 of the existing members voted on this application, it certainly was a valid action by the planning board. Sorry. Okay, and then the last case for SECRA, Evans versus City of Saratoga Springs. The city adopted a comprehensive plan update, and based upon that plan, rezoned various parcels, including one with a hospital in a residential district, to a district that accommodated businesses, medical offices, and health-related institutional facilities, which basically legalized this pre-existing non-conforming hospital use and allowed it to potentially expand or redevelop its facilities. So prior to the rezoning, the city council had engaged in environmental seeker review and ultimately issued a negative declaration finding the proposed rezonings would not have a significant adverse impact on the environment. The city council did not consider any site-specific development of the hospital parcel, explaining that they did not want to speculate or evaluate a hypothetical hospital expansion, and that if a development application was submitted, it would be reviewed by the lead agency and would be no less protective of the environment than a hypothetical speculative review undertaken now. Petitioners challenged the rezonings, including for the hospital parcel, and argued the city council had engaged in impermissible segmentation by not considering the site-specific redevelopment of the hospital property at the same time concurrently with the rezoning of that property. So segmentation, it's one of those scary words that you hear a lot. So the court was nice enough to give us a couple of definitions of what that means. So segmentation is the division of the environmental review of an action such that various activities or stages are addressed as though they were independent, unrelated activities needing individual determinations of significance. Now, segmentation is not always impermissible. It is impermissible when the environmental review of an action is divided into smaller stages to avoid the detailed review called for under SECRA. So if you try to break up different sections so that the individual parts separated out don't seem as big of a deal or as impactful as if you look at the whole thing together. So that's what you don't want to have with segmentation. But segmentation is allowed when the lead agency clearly sets forth the reasons for supporting segmentation and demonstrates that such review is clearly no less protective of the environment, which is what the city council actually exactly tried to do in deciding not to consider any such redevelopment proposal, because from their perspective, it would have been hypothetical or speculative. And so it wouldn't have been a productive investigation without knowing what was actually being proposed. The court said it was impermissible. So, which it's a tough decision. The court explained the rezoning was the first step in the process to allow the hospital's redevelopment plans. And even though the hospital had not yet submitted an application for redevelopment, the court found the potential for development of the parcel was not so attenuated from the zoning map amendment to allow them to be considered separately. And the reason for this was because the hospital was out there putting out pamphlets and flyers and frequently asked questions to the public about all their great new plans for this property. So they hadn't actually submitted anything to the town, but they had been out there advertising and trying to garner all of this public support for what they were contemplating doing. And that was Exhibit 1 to the petitioner's Article 78 proceeding, was those documents showing that there was a concrete plan, that it was not speculative or hypothetical. It talked about a 3-story office building with 300 parking spaces. It was very specific. So it was a tough spot for the city council to be in, because even though nothing had yet been submitted to the city, and you can only speculate, frankly, as to what the city knew about their proposal, if anything, the city was expected to do an entire seeker review on that redevelopment, in addition to considering the rezoning of various parcels, not just the hospital parcel that came out of the updates to the comprehensive plan. So from a practical perspective, it probably is not the end of the world, because the city council had acknowledged there was going to have to be a site-specific seeker review on the project itself when that time came. So what I anticipate would happen is that the applicant comes in with the hospital comes in with a proposal. The city does SECRA on that, along with SECRA on the rezoning, which they'd really already done. So, and then they just adopt it all at the same time. So I don't think it would necessarily preclude or really hinder time-wise this development, but it's a significant concept to think about when you're trying to figure out how you're going to handle bigger projects that involve zoning or involve different parts where some may not be developed. You probably want to try to err on the side of caution in keeping things together and consolidated for secret purposes to the extent you can. And then there was also a challenge to the zoning. And another word everyone loves to hear, spot zoning. So the court, even though the court had thrown out the SECRA determination because of the segmentation, it still went forward with addressing the merits of the zoning. And I think it's probably because they anticipated that that issue would be back before them at some point in the future. And so they just decided to address it now while it was before them. So the court explains that zoning determinations, and I alluded to this very early on, zoning determinations are entitled to a strong presumption of validity. Therefore, one who challenges such a determination bears a heavy burden on demonstrating beyond a reasonable doubt, and that's a criminal standard, that's a very high standard, that the determination was arbitrary and capricious or otherwise unlawful. So that's like I said, that's a really difficult standard. The presumption is very much on the municipality side when it comes to zoning. And so the petitioners, like I said, claimed that this was spot zoning, the rezoning of the hospital property. And the court defined spot zoning as the process of singling out a small parcel of land for a use classification totally different from that of the surrounding area for the benefit of the owner of said property and to the detriment of others. And some of the factors the court said that you could generally consider are whether this rezoning is consistent with the comprehensive plan, whether it is compatible with surrounding use, the likelihood of harm to surrounding properties, the availability and suitability of other parcels, and recommendations of professional planning staff. And under those circumstances, the court found that because the rezoning of the hospital parcel was clearly consistent with the comprehensive plan update, because that was where the idea to rezone the parcel came from, and the fact that it had been used as this hospital use for many, many years in the past, that there was no basis for spot zoning, and the zoning was valid. You want to give a code?
Thank you. Yes. I'll interrupt. Also, I just want to ask a question, but I'll give the code first. So the next attendance affirmation code word I'll give is boulders. It's baseball season, and I'm thinking of the minor league team in Rockland. So boulders, that is the next attorney affirmation word. One thing I thought of when you were talking about the examination of alternatives and how the court said that the alternatives still had to be consistent with, I guess, the interest of the developer or the business plan. Do you think that that allows for like a cherry picking of alternatives to some degree? I mean, is it possible that, developer will make a tiny modification of some minor thing and say, oh, it's basically the same, do that again, say it's basically the same?
No, because you still need to use the function of alternatives is to make sure that there isn't a more appropriate or a better use of the property. Sure, the developer is likely going to may try to do that because they have their project and that's the project they want to see go through. But that's why you have the input of the public and the land use boards that put together the scope to outline what those alternatives were. For instance, if you're doing a subdivision and someone wants to do a 30 lot subdivision, maybe an alternative would be, do you cluster it, right? And do you try to put the houses closer together so that you can have more open space? Or do you do a smaller density, a lower density and have fewer units? Or, like I said earlier, the no action plan. I think the concept is more that it can't be so far afield of what is being proposed that it's really completely unfathomable to think that the developer would ever undertake it, or not feasible, right? One of the other things that the court mentioned and that I mentioned earlier is looking at alternative locations that may not be available and may not be conducive to this use. It may be further away from the historic district that was, a big issue in that case. But if it's too small or if it doesn't have a major road to access it, then how are you going to get to Costco? So I think it's like the court said in that, it's all a question of reason. And that's really the standard, is that it has to be reasonable. But to your point, I think if someone says, I want to build 222 unit apartment building, and the only alternative is, well, how about you build a 218 unit apartment building? The court is likely not going to find that the lead agency took a hard look in that analysis.
Okay. I was also just thinking when you talked about segmentation, the example you gave of the hospital, I can see how segmentation in that instance wouldn't be an issue. It sounds like the zoning amendment was just for this one parcel, and so when the ultimate proposal gets put forward, the site specific secret review would pretty much cover all the impacts.
Right.
I'm just, this is also the things that come across my desk when I see proposed zoning amendments that cover multiple parcels. And I get a little concerned when I see the response, well, we'll deal with the impacts on a site specific basis.
I mean, sometimes it's hard when you don't have that information in front of you, or you don't have an application, or a lot of times, from a practical perspective, an applicant may want to know he or she has the zoning in place before they go down the arduous path of trying to get site plan approval. I mean, there's a certain level of practicality to all of this too. And so I think in this situation, it may not have, like I said, in the long run, it probably wasn't that big of a deal. But in other situations, it could be. And it's definitely something that I think needs to be taken into consideration, and people need to be aware of when deciding how to proceed to the greatest extent practicable. I think it just comes back to trying to be reasonable about how you handle these things. And if you need to justify it, doing things in different segments, make the argument for it. But I think a site specific analysis of a big development is going to get the appropriate level of environmental attention.
That's all the questions I have. And again, I'm just checking the Q&A. I'm not seeing any new ones come up. So
Okay, well,
rolling around.
these are the meaty topics, and I'm usually 21 minutes. That's pretty good. So, okay. Wireless telecommunications, Verizon Wireless of East LP versus Town of Wappinger. And so kind of like with statute of limitations, telecommunications cases are often, timing is very important because the Federal Telecommunications Act and the FCC rules prescribe certain periods of time that are deemed presumptively reasonable to process an application. So it's 90 days for personal wireless service facilities citing applications requesting co-locations. And as applicable to this case, it's 150 days for all other applications. And this is called the shot clock. So in October of 2019, the plaintiff made an application to the town for a proposed 150-foot tall monopole cell tower. After making several supplemental submissions at the request of the planning board and its consultants, the application was considered complete on December 23rd, 2019. And that application completeness date is what starts the 150-day shot clock to process the application. In March 2020, the planning board retained a wireless telecommunications consultant to review the application. And after corresponding back and forth with the applicant a few times in comment letters, by April, the consultant was satisfied that the application was complete. Again, we're talking about March, April, May of 2020. So we're in the heart of early COVID-19. But the planning board did still continue to what the applicant perceived to be processing the application with determination and in an effort to try to get it through. So the planning board called for a public hearing to be held in May 2020. And even though the planning board was coming up on the 150-day shot clock, which is effectively 5 months, excuse me, because the applicant believed the planning board was acting reasonably and expeditiously on the application, particularly in light of the pandemic, they agreed to extend or toll the shot clock for a certain period of time. So the planning board holds the planning board's been considering the application for several months. They hold the public hearing in May, and they get a lot of public opposition. After the hearing, the applicant made a supplemental submission addressing the comments by the public. The town's consultants also responded to certain comments raised by an attorney representing the homeowners and refuting those claims. The planning board continued the public hearing into July, at which point it directed its planner to prepare a draft negative declaration ending the secret process. The draft negative declaration included several paragraphs about why the application would not have any impacts on scenic or aesthetic resources. At the July 20th public hearing, the planning board closed the public hearing, but then asked the applicant to provide a lot of new information related to visual impacts, real estate appraisal reports, and alternate locations, which are issues that had been discussed and explored with the planning board months earlier. But now that there had been public concern raised about it, the planning board was rehashing those issues. And then the planning board chair actually subsequently sent a letter to the applicant advising that their visual tests were defective, which was the first time this was raised in 7 months since it had first been submitted. Despite all of these comments, the applicant again agreed to extend the shot clock to August 31st, 2020. And then a few days later on September 9th, remembering that in early July, the planning board had directed that a neg deck be prepared at the planning board September 9th meeting. The planning board directed that a positive declaration be prepared. And that would not end the secret process. That would not put the planning board in a position to make a determination on the applications. It would require the preparation of an environmental impact statement, which positive declaration the planning board ultimately adopted in September. So the plaintiffs went to court. They didn't wait to do an EIS. They didn't wait to get a determination. They just went to court. claiming that there were various violations of the Telecommunications Act and the FCC rules. And it was a very lengthy decision. I'm going to try to go through it relatively briefly. The court explains that Congress enacted the Telecommunications Act to promote competition and higher quality in American telecommunication services and to encourage the rapid deployment of new technologies. One of the ways Congress did this was to reduce impediments imposed by local governments by putting limitations on the traditional land use authority, including through the implementation of the shot clock. So the plaintiff's first claim was that the planning board's failure to act within a reasonable period of time, a shot clock violation. And while the court acknowledged that the 150-day time period was what was deemed presumptively reasonable for processing the application, there were certain circumstances where legitimately the municipality may need more time. And so at first blush, it's up to the plaintiff who's challenging the agency determination to establish a presumption that the municipality's actions and the time frame it took them were unreasonable. And the court said that the plaintiff had established that presumption in this case. The planning board hadn't made a decision by the time the complaint was filed in October, which was 158 days of non-told time, which the court said established the presumption. The court also noted that since the litigation was commenced, the town had actually stopped processing the application. And the town said, well, that's our normal process. If something's not in litigation, we're not going to keep processing the application. And the court said that was not supported by the Telecommunications Act, and there was no basis for that. And that just furthered the implication in the eye of the court that the town was really just trying to delay. So now that this presumption that the time was unreasonable had been established by plaintiff, it was up to the town. The town had the opportunity to try to rebut the presumption that they had acted unreasonably. And they made various justifications to try to sell that to the court. And unfortunately for the town, they failed. So the first argument was that they needed time to retain a consultant to review the project. The court said, yeah, but you retained your consultant in March and they were satisfied in April, which was a month before the shot clock expired. So what more time did you need? The next argument was the COVID-19 pandemic. And the court said, we understand that was a difficult situation. It's still difficult, but you can only use COVID-19 as an excuse for so much. And in this situation, the shot clock, the 150-day shot clock, was more than halfway through by the time the states of emergency and everything went into effect, and municipalities and public meetings started to shut down or change their format in mid-March. In addition, the applicant had actually given the town twice as much time as they were otherwise entitled to under the shot clock because of the pandemic. So the court said, we get it, but you can only take that so far. You can't use that to just indefinitely not do what you're supposed to do. And more to the point was that the town had continued to hold their meetings. So it wasn't that they weren't able to hold their meetings, weren't able to engage the public. They did get a handle on that relatively quickly. The town also argued that once they started holding the public hearings, they had a lot of new comments from the public that they had to address. And the court really rejected that because a lot of the arguments that had been made by the public were comments that had been raised and addressed at the planning board level before the public hearing had started. In addition, the public hearing was opened in May, and plaintiff didn't bring this action until October. So it had essentially an extra 150 days to try to move this project forward before the shot clock expired and the litigation commenced. So the court explained that none of those arguments rebutted the presumption that had been set by the plaintiff. What the court also made clear to note is that the FCC rules don't just require the planning board to take action on an application. For instance, issuing a positive declaration is taking an action on an application, but to resolve the application by the shot clock deadline. So that's a big distinction, because if you just have to do something, sure, you could do a pause deck on the 150th day and you wouldn't be in violation, but then by the time the EIS is done and you go back and forth on various drafts, that could be a year, maybe more. But the intent is that the application needs to be finally resolved within 150 days, one way or the other. And that was not the case here. So what the court found was that the positive declaration was a pretext for further delay on the application, especially in light of the history of the application. The court explained that while the planning board did take action, it wasn't meaningful. And to accept the town's arguments, there are any number of ways that municipalities could delay with hearings and requests and counter submissions that would effectively mask a denial. The court also noted that the substance of the draft neg deck that had been prepared versus the positive declaration that was ultimately adopted was night and day. The neg deck was bolstered by analysis, evidence, support, and the positive declaration was just conclusory statements. And that was another thing that the court said, is that, you know, if you're going to do a positive declaration that's going to make this process go longer than it should under the shot clock rules, you need meat behind this. You need a basis for saying that there are going to be impacts, and these were all conclusory. So what the court ultimately determined is the plaintiff wanted the court to direct that the planning board had to issue the approval, and the court said no. They would do that in a circumstance where the board had made a determination, but it wasn't supported by substantial evidence. And then if that was the case, then they would direct an approval. But because there wasn't actually a determination here, instead the court directed that the planning board had to make a decision on the merits within 60 days. I have no idea how that's supposed to happen when the last action the planning board took was the adoption of positive declaration. And that may be another case where we see some more on this in the coming years. Excuse me. Okay, last topic. Religious uses. So this used to be under the heading of our LUPA, but there was a case, and generally that's where religious use cases come up. But I think it's important to remember that religious and educational uses are also given special treatment and protected to a certain extent under state law as well. So I kind of broadened that scope a little bit. So the first case is Sid Jacobson Jewish Community Center, Inc. versus Zoning Board of Appeals of the Incorporated Village of Brookville. So JCC, which is a nonprofit, non-sectarian Jewish organization, operated a day school and camp on its property in a residential zoning district. So they basically wanted to expand their existing building, but it looks like it was probably a legal non-conforming use. And so they needed some sort of authorized use of the property in order to be able to expand. So they went in for a conditional use permit. And under the Brookville Code, they have a safety net where they allow a conditional use permit for any use in any non-residential uses which may not be excluded pursuant to state and federal laws. And the big ones that those would encompass are religious and educational uses. And it's a pretty smart approach by the village because it avoids any claims that the code's unconstitutional. And it also provides a mechanism to review those uses as conditional uses with some additional oversight. So in this situation, though, the zoning board did deny the conditional use because on the grounds that the JCC's use of the property didn't fall within the code's conditional use definition. Because the conditional uses were uses that may not be excluded pursuant to state and federal laws. But in this case, that they weren't actually religious or educational uses that have those protections that they cannot be excluded. So even though JCC was a religious organization, the activities and programs offered at the day school and camp were standard recreation activities offered at any summer camp. In addition, the camp was recreational, not academic in nature. The court noted that the camp was operated under a children's camp permit from the county DOH, like all other recreational summer camps, and the activities that were offered were athletic and recreational. And there was no evidence that the staff was qualified to instruct on educational matters. So while if this had been an actual religious or educational use, this special permit use would have been something that would have been a catch-all for that use and given a mechanism to be permitted. In this case, even though the organization had a religious affiliation, because the use itself was not religious, the court found that the ZBA had properly determined it didn't fit in that category. Then the last case I'm going to talk about is an interesting one. Woodcliff Lake Citizens against Overdevelopment versus Borough of Woodcliff Lake. So what's interesting about this case is that it considers our LUPA from a perspective that we don't often see it, which is settlement. We see cases, we see decisions from the courts, we see appeals, we see everything go back and forth lots of times over years. You often don't see the settlements because they don't often appear back in court, but this kind of gives you a glimpse into what happens in some cases after the RLUPA litigation commences. So Valley Chabad filed an application with the zoning board to construct a 12,247 square foot house of worship on a 1.27 acre lot in a residential zoning district where they had worshiped since 1996. The ZBA denied the application, and Valley Chabad brought a litigation alleging RLUPA violations, among other constitutional claims. 2 years later, the Department of Justice actually filed its own lawsuit against the municipality, also claiming RLUPA violations. So now they have two RLUPA violations against them, one by the applicant and one by the Federal Department of Justice, which is a little more than a little daunting. So after engaging in discovery, the parties then engaged in lengthy settlement discussions over the course of about 18 months and with the oversight of the court, and they were able to reach a settlement in principle. The pertinent terms were that while the municipality denied liability, they agreed to make a $1.5 million payment to Valley Chabad. The parties agreed to a site plan whereby the municipality would grant 9 variances and 5 waivers so that Valley Chabad could construct a 19,825 square foot facility, which is 62% larger than what they were currently proposing before the RLUPA litigation started. And to settle the complaint with DOJ, the municipality agreed to implement certain measures to avoid future RLUPA violations. So because this was a settlement by a municipality, it had to be approved by the municipality's legislative board. And again, we're in August 2020 now, so we're still in COVID time. And so the public meetings that were held on this matter were held virtually. The board held public hearings at 2 meetings. The meetings went about 2.5 to 3 hours each. They received a petition from 500 residents opposing the settlement. And at the board's September 14th, 2020 meeting, the board voted 4-2 to approve the settlement. And this was another case where the petitioners who were a local citizen group, plaintiffs who were a local citizen group, also challenged the procedure and the efficacy of the technology in the public hearing and public meeting process. But the court determined that it was not a constitutional due process violation. And I'm not really going to get into it any more than that because I already talked about it a little bit in some other cases. So a citizens group brought a lawsuit challenging the board's approval of the settlement on the grounds that it was a gross misapplication or weaponization of our LUPA and that it violated the residents' due process rights because of issues with the virtual hearings. The court explains that our LUPA prohibits governmental action that discriminates or results in unequal treatment on the basis of religion or imposes a substantial burden on the religious exercise. The court also referenced our LUPA's safe harbor provision, which allows the municipality to avoid the preemptive force of our LUPA by changing its policies or application of policies to remove the substantial burdens on the exercise of religion. The court observed that by settling in this case, the municipality, without admitting liability, incurred expenses and altered specific zoning policies. That is consistent with our LUPA in action. At times, the policies and practices of a municipality bend in favor of the broad protection of religious exercises. The statute's remedial goals have resulted in settlements in which municipalities have redressed identified harms caused by their land use policies, frequently to the dissatisfaction of residents otherwise benefiting from those policies. The court also noted that in reading plaintiff's complaint, it reflected the not unusual or unexpected reaction of local citizens protecting the impact of a successful RLUPA lawsuit. So then the court went into the specific claims that the plaintiffs had made, and I'll run through this quickly because I know I'm running out of time. The plaintiffs claimed that the settlement was a rush to judgment, and the court said it certainly was not. It may have seemed that way to the public because it only came to their attention in July that there were going to be public meetings held in August. But the reality was that this had been going on for years before it actually got to the point where there was a viable settlement that could be presented to the public. There was the litigation being commenced. There was discovery. There were settlement discussions for over a year. So it certainly was not a rush to judgment. The court, even though the settlement plan required several variances, the court noted that not only was the plan approved by the legislative board, but it was also reviewed by the municipality's technical consultants, who determined that it was not overly burdensome. And in response to plaintiff's claim that Valley Chabad was getting a free pass to ignore zoning rules and regulations and to entirely throw them out the window, the court explains that under the settlement, the applicant will still have to comply with several environmental code and site requirements before construction could commence. And lastly, plaintiffs claimed the settlement poses an undue burden on residents and effectively results in, quote, reverse discrimination. The court found this assertion to be based upon a misunderstanding of the context in which this litigation arose. The purpose of a settlement was consistent with RLUPA's remedial purpose and effect to prevent discrimination against Valley Chabad and alleviate any substantial burden on its religious exercise. The court concluded by saying, any proposed burden on the municipality and its residents is an inevitable consequence of resolving RLUPA litigation, which Congress anticipated when drafting the statute and requiring its remedial construction. So I thought that was interesting because it talks about, what happens when parties are trying to work this out after RLUPA litigation commences. And I also thought it was interesting to see what the settlement looked like as compared to what the application initially was. By denying it in the first place, the municipality ended up paying $1.5 million and agreeing to a plan that was more than 50% larger than what was originally being sought. So, it was certainly an interesting perspective and not a case that I've seen much like that. So 901, I'm not going to address the last case, which is Congressional Rabbinical College of Tartikoff versus Village of Pomona. This was on the handout from last time. And there has been an appeal filed to the Second Circuit on this. So maybe by the lecture in the fall or next spring, we'll have another update on whether the appellate court upheld this or reversed it. And I'll stop.
All right. Well, I still don't see any questions, so I'll maybe give people a minute just if they need to type anything out. But we are at 9:01, so we are at kind of the end of our time. So I'll keep monitoring, see if any questions come up. But I just wanted to first of all say thank you very much, Christie. Thank you for you've come back a few times now, and I appreciate you always sharing your knowledge and your experience. I think we're very lucky to have you here. And I also want to thank everyone for joining us tonight. Thank you for the time you volunteer to your community, and I hope you enjoyed the session. Again, if you are on a board outside of Rockland County and need a certificate of attendance, or if you just have a question about anything, please send me an email. I put my email in the chat. Also, I should probably do one last attorney affirmation code word. Since I came up with it, I'll use it. The last one of the evening is Hudson, as in the Hudson River. So that's the last attorney affirmation code word. I do see a couple of questions have come up. Did not hear the code and I've been on since 7. Well, I am sorry, I'm not going to jeopardize the possibility of other people getting the CLE credit. I'm not sure why you did not hear it, but I did say it. And will this recording be available to review at another time? The Federation has maintained or started a YouTube channel. So in a few days, give me a few days and I will be able to put this up on YouTube.
I didn't know about that.
Yes, we have a YouTube channel. So lastly, I just want to remind everyone that we have session 3 for ZBA members coming up on March 31st. And session 3 for planning board members on June 16th. And anyone who wishes to vote in the Federation election, please hang around. I will put a poll up in a moment, but for everyone else, thank you very much and good night.
Thank you, guys. Have a happy, safe holiday weekend.
Thank you. Thank you very much.
Take care.
Thanks, Christie. Great job. Good night.
Hopefully
Enjoy
see
your
you guys
weekend.
soon.